Hello. Lively, I'm recording this now after the hearing, so I'll do a separate short video on a summary of what happened in the hearing. But Lively, just before the hearing, filed another letter to over this whole motion for judgment on the pleadings. So I'm just going to quickly go over that. Dear Judge Lyman, Plaintiff Blake Lively respectfully moves for leave to submit the following reply to Wayfarer Dependents letter brief, in opposition to her motion regarding the Wayfarer Dependents motion for judgment on the pleadings. In particular, the Wayfarer Dependents response for the first time seeks an extension of the discovery schedule and of the summary judgment schedule that pose a risk to the March 2026 trial date. While Miss Lively is amenable to reasonable extensions consistent with that trial date, the Wayfarer Dependents proposal is not that. And in no circumstances should the compressed schedule between now and March 2026 be extended to squeeze in a Rule 12C motion that could have been filed months ago and which raises arguments that could be raised only weeks from now at summary judgment or at trial if the Wayfarer Defendants prefer. The Wayfarer Defendants propose an extension to the existing schedule that would result in the parties' respective summary judgment motions becoming fully briefed on January 5th, 2026. But the proposed joint pretrial order in this case is due on January 23rd, 2026, only 2.5 weeks later, rather than the 8 weeks and 2 days allowed by the existing original schedule. While Miss Lively has no doubt that the court will dispose of any summary judgment motions efficiently, allowing only 18 days for the court to decide what may be extensive motions, and then for the parties to confer and prepare the proposed joint pre-trial order, not to mention motions in limine, is not warranted by the circumstances giving rise to the Wayfarer Defendants' request. The Wayfarer Defendants may respond, as they did when Miss Lively opposed the timing of their motion, that the joint pre-trial order deadline and perhaps even the trial should be adjourned to make room for their request and to make their motion seem more timely than under the existing schedule. But such downstream efforts on trial scheduling are exactly why their motion was untimely under Rule 12C in the first place. On March 21st, 2025, shortly after filing their answers, the Wayfarer Defendants Lead Counsel boasted in the media, "We strategically made decisions to file answers to these complaints." The Liner, Friedman, Titleman, and Cooley LLP co-founders stated, "This is not because we do not have grounds to file motions to dismiss, but because in this day of courts given wide discretion for leave to amend, we are not interested in providing them with a chance to learn just how poorly their legal theory has been drafted and a roadmap on how to correct it." I remember Friedman saying that. At the time Mr. Friedman made that statement, trial was already set for March 9th, 2026, as it has been since January 27th, 2025. The Wayfarer Defendants and their counsel made their strategic decision to delay any challenge to the sufficiency of Miss Lively's pleadings with full knowledge of that date. Ultimately, they waited long enough that the pleadings themselves have been overtaken by evidence accumulated through a discovery process that is almost complete. The timing of the Wayfarer Defendants motion filed such that Miss Lively would be deposing 5 of the 6 individual defendants, not 4 as her letter motion inadvertently misstated, during the 14-day response period, certainly suggests that their behaviour continues to be strategic in the sense of seeking to impose procedural burdens with no corresponding substantive benefit. Oh my God. So she sounds a bit pissed off, for want of a better word, that Wayfarer had basically played a chess move and they basically out-strategized her, and she's not happy about it. I find this kind of ridiculous, actually, given that, the whole Van Zandt of it and everything, all the little strategic moves that she's been pulling. I find it's a bit rich for her to be complaining. What it sounds like she's saying is, this is not fair. They've got me over a barrel. Judge, deny it. The Wayfarer defendant's reasons for opposing Miss Lively's letter motion only further confirm these points. First, the Wayfarer defendants suggest that the timeliness of their motion should be judged against Miss Lively's July 30th second amended complaint. But as the Wayfarer defendants know, that amendment was limited to jurisdictional allegations relating to the Wallace defendants, i.e., the only defendants who have not joined the present motion. The allegations to which the motion is addressed have been unchanged since February 18th. Second, the Wayfarer defendants make hay of the fact that their motion is addressed only to the sufficiency of Miss Lively's pleading, and thus any evidence obtained in discovery would not be relevant. I really have a problem with this. Wayfarer defendants know that Second Amendment was limited to jurisdictional allegations. Yeah, but that's exactly what they're saying. She made such a fuss that she was harmed in New York, she lives in New York, the film was shot in New York. And that's what they're saying. Well, you've said it yourself that your claims all revolve around New York, so you cannot, lean on a California state law. But that misses, right, I'll read that one again now. Second, the Wayfarer defendants make hay of the fact that their motion is addressed only to the sufficiency of Miss Lively's pleading, and thus any evidence obtained in discovery would not be relevant. But that misses Miss Lively's point. Even if there were any issue with the second amended complaint, Miss Lively has now, unlike in February 2025, conducted extensive discovery and would be in a position to cure those defects through an amendment that the court must grant freely as justice so requires. The Wayfarer defendants seem to think that by timing their motion as they have discovered a loophole in the rules that would require this case to be decided based only on what Miss Lively knew before discovery rather than after it. And this is a woman who wanted to be dismissed and not be put through discovery because it was abusive. But that is the opposite of how Rule 15 works. And indeed, courts routinely grant leave to amend when a plaintiff seeks to refine the complaint to reflect evidence obtained during discovery. As explained in Miss Lively's letter motion, Wayfarer defendants' fact-bound challenges to the sufficiency of Miss Lively's pleadings will only lead to unnecessarily duplicative work on the sufficiency of a proposed amended complaint, work that could be done just as well and more efficiently at the summary judgment stage. Third, and finally, the Wayfarer defendants profess ignorance of how their motion could delay trial, but an unnecessarily duplicative motion can only cause delay to the extent it has any impact at all. The Wayfarer defendants do not dispute that they could raise all the same arguments at summary judgment and will suffer no prejudice whatsoever from waiting that long. Balanced against the risk of uncertainty burden and delay, their motion is not timely. All that said, Miss Lively is amenable to a reasonable extension of the current discovery and summary judgment schedule if, and only if, it would be consistent with the court's ability to manage this case to the March 9th, 2026 trial date. In particular, Miss Lively would agree to extend the existing deadlines by 1 week each, such that opening expert reports would be due October 17th, rebuttal reports would be due October 31st, and summary judgment motions would be due November 12th. That summary judgment deadline is appropriate given the scheduling considerations discussed above, and would still permit the Wayfarer defendants nearly 4 weeks following initial expert disclosures to depose Miss Lively's experts and incorporate that material into a summary judgment motion as appropriate. And as a footnote, in this regard, Miss Lively notes that the Wayfarer defendants agreed to the present expert discovery schedule, which set the last day for depositions at November 14, which, without requesting any extension of or otherwise addressing the November 5th summary judgment deadline. To further facilitate that schedule, while the last day for expert depositions would remain November 14th, Miss Lively is prepared to commit to make her experts available for depositions between October 24th and November 5th. Miss Lively opposes any greater extension for the reasons set forth above. Finally, the Wayfarer defendants oppose Miss Lively's motion to clarify or extend the deadline to serve requests to admit. Apparently unconscious of the irony that they have asked for an extension of the summary judgment deadline, which has been on the books since February, and which they did not seek to extend in the course of prior amendments to the expert schedule, while opposing an extension of the RFA deadline, which has been on the books since February, in which the parties and the court apparently overlooked in the course of prior amendments to the schedule, so it's also the judge's fault now. The Wayfarer defendants have no real objection to the extension, only feigning surprise that Miss Lively did not serve RFAs by a deadline that had originally been set for the last day of fact discovery. Of course, neither did the Wayfarer defendants. There was a reason for that original schedule, and there is still a reason to permit the parties to exchange RFAs informed by discovery, so that they can serve their purpose of reducing trial time. So, that is the letter from Blake Lively's team, like a further response to Wayfarer's request for judgment on the pleadings motion. So, I will leave it there. I will now go and do the summarization of the hearing separate. Thank you, and I'll see you soon.